On one fine afternoon, Emma met David Kasher, a foreigner, while taking a walk at the park. Long story short, they fell in love. Emma and David Kasher got married in Sanur, Banu Regency on 1st May 1997, which was attended by both close families and friends. They had a child named Marcus Kasher, born on May 5, 2002. A few years later, Emma found out that David has an affair with another woman. For that, Emma and David fought every day. Emma was still being patient because she didn't want her child to deal with the separation from both parents at his early age. But after a long thought, Emma decided to file a divorce lawsuit in Denpasar District Court.
What are the legal issues for this case? So the legal issue for this case is a divorce between an Indonesian citizen with an American citizen. Argument by the plaintiff. First, that the plaintiff is the legal wife of the defendant, is registered in the Department of Population and Civil Registration Office, namely the marriage between an American citizen and an Indonesian citizen, and according to the marriage certificate number 80/B.4/WNA/1997 on 1st May 1997. Second, that from the marriage between the plaintiff and the defendant, a son named Marcus Kasher was born on 5th May 2002 in accordance of the birth certificate number 11/UM.DB/2002. Third, whereas at the first the marriage between the plaintiff and the defendant went normally, like a harmonious husband and wife relationship, until there was a dispute between the plaintiff and the defendant around 2010. Number 4. Whereas in 2010, the plaintiff heard that the defendant had an affair. Since 2003 until now, the defendant has no longer provided physical and spiritual support to the plaintiff even though they are still living under the same roof. Number 5. Whereas in the order to avoid unwanted things that may occur, such as domestic violence and others, sometimes the plaintiff stay overnight at the plaintiff's relative's house. 6. Whereas the child of the plaintiff and the defendant named Marcus Kasher live with the plaintiff on a daily basis. He is still in high school, which is of course really requires a lot of daily living costs of total 10 million rupiah per month, which is borne by the defendant until the child graduates from college and can live independently. Argument by the defendant. There was no argument from the defendant because the defendant was not present at the trial, even though he had been properly summoned.
The court's considerations. Number 1. Considering whereas the intent and the purpose of the plaintiff lawsuit is an annulment of the marriage between the plaintiff and the defendant due to divorce with all of the legal consequences. Number 2. Considering whereas even though the defendant was present at the trial, the plaintiff still has to prove the arguments for her claims as stated in Article 283 RBG. Number 3. Considering that the divorce can only be carried out on marriage that are legal according to the laws of each religion and belief, as described in Law Number 1 Year 1974, besides that it must also be recorded according to the applicable laws and regulations. Number 4. Considering that the custody of the child born between the plaintiff and the defendant was given to the plaintiff according to the panel of judges is a natural thing because the defendant already had an affair. Number 5. Considering that regarding the cost of living for the child, the plaintiff still hasn't proven how much the defendant's income is, and this kind of cost will change over time. Therefore, the panel of judges think that the child's living expenses are not solely the responsibility of the defendant but the plaintiff as well. Number 6. Considering that the divorce can only be carried out if the parties report the divorce decisions, which has a permanent legal force, to the Population and Civil Registry Office of Banu Regency within a grace period of 60 days. The court's decisions. Number 1. Stating that the defendant was not present even though he had been properly summoned. Number 2. Partially granted the plaintiff claim with first step because the defendant was not present at the trial. Number 3. Declared that the marriage between the plaintiff and the defendant had been annulled or broken up due to divorce. Number 4, stating that the plaintiff still has the custody of the son from the marriage with no obstacle whatsoever if the defendant wishes to meet and give affections, and the living cost of the child is the responsibility of both the plaintiff and the defendant. Number 5, order the party involved to report its divorce decisions, which has a permanent legal force, to the TK2 Badung Regional Civil Registry Office for registrations and the issuance of the divorce certificate. Number 6, sentencing the defendant to pay court fees in the amount of 901,000 rupiah. Number 7, reject the plaintiff claims other than the rest.
Why is this case considered as private international law case? There are a few points. First, plaintiff, Indonesian citizen. Second, defendant, American citizen. Third, they both get married in Indonesia or lex loci celebrationis. Fourth, a child was born from their marriage, named Marcus Kessier. And the last, the divorce lawsuit as well as the child custody application was filed by the plaintiff through Denpasar District Court. According to Professor Mokhtar Kusuma Atmaja, the international civil law is the entire rule and legal principle that regulates civil relations that cross national borders. In other words, the law that regulates civil law relationships between legal actors, each of which is subject to different national civil law. This case is included in realm of international civil law because there is a foreign element in the legal relationship. Namely, there are foreign citizens, United States, who divorce with an Indonesian citizen.
So what does this case have to do with the theory of acquired rights? The theory of acquired rights means that the rights that have been obtained under foreign law are recognized and fully implemented by the judges in the country of origin, or rights that have been obtained abroad are recognized and respected by the country of origin. If the divorce is from a marriage of different nationalities, in which one of the parties is an Indonesian citizen and the other is a foreigner, from a marriage which was held in Indonesia, legal consequences will arise here, in particular of what law is applied in the divorce. It can be said that the rights that have been obtained through marriage between the plaintiff and the defendant are legal under Indonesian law and also under the US law. The child custody born between the plaintiff and the defendant can also be recognized by both Indonesian and US law. The child resulting from a marriage after divorce does not erase the child's civil rights against his father, the defendant, even though the child is an Indonesian citizen. Why an Indonesian citizen? Because the United States adheres to the ius soli principle, namely the citizenship based on where the child was born. And so, Emma got the child's custody from her divorce with David. They even moved to a new city to start a new life, and it was the perfect ending everyone could hope for.